This is your jury charge performance challenge reading for week number 10. Paragraph. Members of the jury, at this time, you have heard the evidence and the arguments of counsel, period. I want to remind you that the court and the jury do have different jobs and functions, period. Paragraph. You, the jurors, decide the disputed facts, period. It is the job of the court to provide you with the instructions of the law, period. It is your sworn duty to accept these instructions and to apply the law as given to you by me, period. You are not permitted to change the law or to apply your own idea of what you think the law is or should be, period. Paragraph. A criminal case begins with the filing of an indictment, period. This indictment tells the defendant that he has been charged with a certain offense, period. The fact that it was filed against the defendant may not be considered for any other purpose, period. Paragraph. The plea of not guilty by the defendant is a denial of the charges, and it puts in issue all the essential elements of each offense, period. Paragraph. The defendant is presumed by the law to be innocent until his guilt has been proven beyond a reasonable doubt, period. The defendant may not be convicted of an offense unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense, period. Paragraph. I will now define reasonable doubt, period. Reasonable doubt is present when, after you have carefully considered and compared all of the evidence, you cannot say you are firmly convinced of the truth of this charge, period. Reasonable doubt is a doubt based on reason and common sense, period. It is not a mere possible doubt because everything we do is open to some possible or imaginary doubt, period. Paragraph. Proof beyond a reasonable doubt means proof of such a character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs, period. Paragraph. If, after a full and impartial consideration of all the evidence, you are convinced of the truth of the charge, beyond a reasonable doubt, then the state of Oklahoma has proven its case, period. Evidence consists of all the testimony that has been received from the witnesses and the exhibits that have been introduced in this courtroom during this trial, period. The evidence may be direct or circumstantial or both, period. Paragraph. Direct evidence is testimony given by a witness who has seen or heard the facts about which he or she testifies, period. It also includes the exhibits admitted into evidence during this trial and anything that has been agreed to by the attorneys, period. Paragraph. Evidence may also be used to prove a fact by inference, and this is referred to as circumstantial evidence, period. This type of evidence is the proof of facts and circumstances from the evidence from which you may infer other reasonable facts and circumstances, period, paragraph. If you do not have good direct evidence, a case may be decided only on circumstantial evidence. All of this must be proven by a reasonable doubt, period. If there is a combination of two types of evidence, both of the two must satisfy you of the defendant's guilt beyond a reasonable doubt, period. Just remember that evidence does not include the indictment or the opening statements or the closing arguments of the attorneys, period. They are given in order to help you, but they are not evidence, period. They are just the opinions from the evidence about their side of the case, period, paragraph. Statements or answers that were stricken by the court or which you were told to disregard are not evidence, period. They must be treated as though you never heard them, period, paragraph. It is not your job to try to understand why the court sustained an objection to any question or what the answer to that question might have been, period, paragraph. You are the sole judges of the facts in this case, the credibility of the witnesses and the weight of the evidence, period. In order to weigh the evidence, you must look at the credibility of the witnesses who have come before you, period, paragraph. You must look at the appearance of the witness upon the stand, the way that he or she has testified, whether the testimony was reasonable, and the opportunity that he or she had to see, hear, and know the things about which they are testifying, period, paragraph. There are many things to consider when you are judging credibility, period. Please remember that it is not necessary that you believe the complete testimony of any witness simply because he or she was under oath, period. You may believe or disbelieve all or any part of the testimony of any witness at any time, period. You must decide if the testimony given is worthy of belief, period, paragraph. It is important for you to understand that it is not necessary that the defendant go on the witness stand and testify in his own behalf, period. He has the right to remain silent during his trial, period. The fact that he did not testify must not be considered by you in any way, period, paragraph. At some times, an attorney may call a witness to give what is called expert testimony, period. This has happened in this case, period. You must remember, however, that the testimony of an expert is only his opinion, period. As with any other witness, you as the jury must decide what weight you will give to this expert testimony, period. It deserves no more weight than what you would give any other witness who testifies before you. Period. Paragraph. The defendant in this case, comma, Michael J. Period Collins, comma, is charged with transporting marijuana across the state line. Period. The charges are set forth in one count of this indictment. Period. It will be your job to find the defendant guilty or innocent of the offense that has been charged in this indictment. Period. Paragraph. I am now finished with the instructions that you are to be given. Period. It is now time for you to retire to the jury room to begin your deliberations. Period. The first order of business for you will be to select one of your members to be your foreperson. Period. This person will speak for you here in open court. Period. Please go with the bailiff at this time to the jury room. Period. Paragraph.